Yes! Hello, my beautiful friends. What an amazing day it is, and welcome back. I hope that your week is unfolding oh so beautifully well, and you're hunkering down while Mama Elon and Papa Trump are throwing dishes at each other in the kitchen. We're just gonna keep our eye on that back there while we go to the Supreme Court's house today and hang out with them. But it's going to be a great stream. We got a lot of stuff to talk about. Of course, Elon and Trump having a little bit of a kerfuffle, and we'll see what you have to say about that. But we got some really good Supreme Court news to attend to as we take a break from this political domestic violence that's happening on X right now. We're going to see what's happening in the Supreme Court because, golly, we had some pretty nice victories today in a couple of different cases, and I'm excited to share with you what came out of there. We're talking about this case, Marlene A. Ames. She is a petitioner, and she has been victorious. And what's interesting about this petitioner is she is a straight white woman. Oh, you can even see that SCOTUS blog is saying the same, and the straight white woman won. Whoo! She claims she was subjected to reverse racism, and it was a very interesting case that came back down. We'll read through it. She had a lesbian boss who demoted her and then hired some other gay and lesbian people. The whole case is wild, so we'll read through it. Nice victory. It looks like it was a 9-0 decision that came out from the Supreme Court, and it came from Justice Ketanji Jackson, which is curious. So we'll read through it. Nice victory. Reverse discrimination. Give me a break. It's all discrimination, and now we're seeing the Supreme Court come out and call it what it is. Then we'll change gears. We'll talk about what's happening in the Smith and Wesson case because the Mexicans sued, and they were very unhappy about guns and other things, and now Smith and Wesson won on this one too, saying, and this is really great because earlier, I think this week, maybe it was last week, where we saw that the Supreme Court punted on another gun rights case. But in this decision, which was drafted by Judge Kagan, she is confirming for us that AR-15s, they're so-called assault rifles, those are actually common and in widespread use. And so what that means is we've got some nice precedent in this case that's been anchored in, which means when we come back on this issue, we're going to look pretty dang good. So that's coming up. Then we're going to talk about the spitting lib. Remember her? This one right here. Benny Johnson, thanks for the clip. Remember her? She came up to Ed Martin. Yeah, tyranny, patriarchy. Remember her? Well, we had some comments about this. Obviously, she was charged with a crime. We've talked a lot about that. But now she's in more trouble. And what's curious is when we were talking about her case originally, there was a question about whether or not her social media posts would come back to bite her in the booty, and now they are. So what we'll see here is the DOJ submitted by Jacob Green. What's up, Jacob? He sent this one in. Prosecutor says, how about it's time to revoke her bond, revoke her conditions of release, and bring her butt back into jail because she is still posting at Ed Martin. This whole thing has been going on. She's already been charged. And so they submitted this motion to revoke or to adjust her petitions of release conditions or conditions of release. And what we'll see in here is she's still tweeting at the dude. She's still sending tweets at him, even though he's the victim of her maniacal violent crime, which was an attack with her disgusting looginess. And so all of that is coming up on the day, and we're very glad that you're here and with us. And to our Rumble friends, my apologies. Hopefully we're coming in loud and clear on all the tubes. We have now revamped all of the tubular systems, and so hopefully that does not happen again. And we're excited about this, actually. I think it's going to give us some cool features and benefits. But we have a great stream planned ahead. Now, before we get into any of this, one thing we want to talk about is getting healthy. And we got to face it, okay? All of us are getting older. Age hits all of us. Whether it's stiff joints, poor sleep, brain fog creeping in earlier than you expected, A lot of this goes back to what's happening at the cellular level, and that's where Fatty 15 comes in. Fatty 15, one of my favorite names. Fatty 15 is powered by this thing called C15-0. It's the first essential fatty acid discovered in over 90 years, originally found thanks to the work and the research of the co-founder of Fatty 15, Dr. Stephanie Venn Watson, when she was with the U.S. Navy, and there they were studying how to improve the health of aging dolphins. Now, they can use that, what helped the dolphins, for humans too. Over 100 studies show that C15 supports stronger, more resilient cells, slows biological aging. As many as 1 in 3 people worldwide have low C15 levels and this thing called cellular fragility syndrome. And so this isn't just about looking younger. It's about deeper sleep, sharper thinking, healthier aging from the inside out. And Fatty 15 is vegan, pure, 3 times the cellular benefit of what you've heard in omega-3s. Now, Fatty 15 is on a mission to optimize your C15 levels to help support your long-term health and wellness, especially as you age. And you can get an additional 15% off their 90-day subscription to starter kit by going to fatty15.com/Robert. Use code Robert at checkout and start the breakthrough in healthy aging backed by science. Links, of course, in the description below. And check out Fatty 15, and we appreciate them supporting today's show. All right, so we got some good business to get into today. We're going to the Supreme Court, and we're in a position right now where Elon and Trump, before we jump into the show, Elon and Trump are duking it out. And right now, honestly, it's hard for me to get too upset about this. When I think back about this, it reminds me of the founding era when we had guys like Alexander Hamilton and Thomas Jefferson at each other's throats, just going at it. And things got pretty provocative back then. But what I see with Elon and Trump right now is 2 guys who are working against essentially the deep state, the oligarchy that we're all upset with. And so no matter how this kind of splices down, I think that ultimately we're going to be the benefactors of this as the American people. And I know it might not seem like that, or that might seem like it's cope or something, but we were talking about this on this morning's members only stream about how sometimes dudes just duke it out. You really have to duke it out. Now, there's some pretty serious cuts that are coming out here, Epstein claims, canceling contract claims and all that stuff. Totally understand that. Can feel like it's a little bit below the belt, and maybe it is. We don't want them to be permanent enemies. But at the same time, we have concerns about handing the party over back to the Republican Party, which has failed dramatically my entire life. And I think that's something that Elon is raising. At the same time, Trump has a government to run. He just got in there. He needs some runway to be able to make some reforms and to turn the ship around. And if he doesn't have any tools to do it, that's not good for anybody. And he might fail before he even gets started. So the way I see it, it's just really kind of a healthy thing, to be honest with you. Anytime that the government is working together and everything is perfect and fluid and there's no problems and what's a great bill, let's pass that bill, it's immediate, then we get screwed, right? The founders in their brilliance created a system whereby James Madison talks about this, I think in Federalist 51, where he says you pit ambition against ambition. You've got 2 dudes with 2 opposite viewpoints on how to do some things. It's not a bad thing because iron sharpens iron. And out of this blood sport, we get some actual benefit and some growth in our country. And if that means rattling all of the senators, if that means rattling the entire constituency of Washington, D.C., that's fine. We're happy to go through it. But the melting down, like our country's over. I've seen people posting on here, like on X, like China won, America's done, the country's over because these 2 dudes are fighting. Give me a break. Okay, if you've ever been in a group project or been on a sports team or something like that, then you know you've gotten into it with other dudes. They've come at you. You've come after them. Sometimes they've gone to blows, but you just chill out and the team goes on and wins. And actually, sometimes those are the best players on the team. The dudes who are willing to get out there and kill each other in order to be the starting quarterback or to be the captain of the team or whatever it is. So right now, what I see is progress and healthy conversations happening in the Republican Party. Now, the Democrats would never do this, right? This is why it's so shocking to them, because they don't have these conversations. They just sit around and do whatever the main party wants them to do in uniformity. And we don't do that stuff. So I think any way we splice this, Trump gets a bill, he gets some runway to do what he wants. Elon, they're going to get a bill. I mean, no matter what's going to happen, a bill will go through, obviously, or not. The government shuts down and all of Congress has a real come to Jesus moment about how this government works now. And all of that, I think, is a good thing for all of us. Whatever happens, we're excited for it. And so I just wanted to say that. And I just got this book of all of Thomas Jefferson and Alexander Hamilton's letters. And I think it was not to Hamilton, but it was to Adams. It was Jefferson to Adams. And these dudes sending letters back and forth, the Federalist Papers back and forth. When our country first got founded, the Supreme Court was going hog wild, like prosecuting people. I mean, what we see here right now is also benign on the relative scale of other conversations that have been happening in American history. And so there's a lot of like depression and anxiety and sadness out there. And I'm just not feeling it. I'm like, all right, like the Epstein stuff. Okay, come on. Like, obviously there's no Epstein stuff. If there was, they would have released it back in 2016, the first time Trump run. They would have released it again in 2020, the second time Trump won. And they would have released it again the third time Trump ran and won. So, I think it's just dudes. Trump's not going to cancel the contracts either. Like, we kind of need Elon to launch those rockets up there. So, all right, let him duke it out. It's like you go to the dog park, let the dogs out. They're going to just round and around we go. And then they're going to be worn out and we'll get back to business. So I think they're on the same team. We're on Team America. I think they're both on Team America. And so I'm actually optimistic about it. Just wanted to share that. Hopefully some other people are feeling that too. But this is good, healthy stuff. We want it in our country. We don't want them to just go along and get along because then we all get screwed. All right, so enough of that. Now, let's get to business, baby, because we got some Supreme Court stuff to attend to. And this is a bit unusual. Wow. A white woman won, and she's straight too. This came out of the Supreme Court of the United States, which is why I know you're shocked. What did you just say? A white woman won in the Supreme Court who's straight? Yeah, it's true. She came out after suing the Ohio Department of Youth Services. Her name is Marlene A. Ames, and we have a photograph of her in some location, which I'll get. But she, of course, is the woman who sued Ohio Department of Youth Services. And the background on this case is wild because she was essentially demoted. She was not promoted, even though she was highly qualified. And her the government for which she was working, this Department of Youth Services, was promoting other people who met certain criteria. And so the Supreme Court came out and issued this nice ruling. And let me grab her actual photograph just so we can see who she is. My apologies. I thought I had this queued up. And here it is in the news. As soon as I can find it. And all right, so your boy's struggling on this one right now. 1 second. We have a slight pause in the show while I pull this up. Ames. Marlene Ames. All right, so here we go. Coming up soon. Here she is. Okay, Washington Post. NPR. This is the one I thought I had queued up. All right. For full posterity, she is a white woman. Okay, just to be clear, we got photographic evidence here now, which is why we had to pause. Marlene Ames is in her lawyer's office back in Akron, Ohio. She claims she was passed over for jobs because this is who she is. That's discrimination. So the Supreme Court came back down, and this came out from Justice Jackson. She says, wow, we all are unanimous in this. They write, all right, Title VII prohibits employers from discriminating against employees on the basis of race, color, religion, sex, or national origin. And under our precedents, a plaintiff, someone like Marlene, may make a showing of disparate treatment, meaning she's been treated poorly, by showing the following: that she applied for an available position for which she was qualified, but she was rejected under circumstances which gave rise to an inference of unlawful discrimination. Okay, so that's the standard. I am working here. I'm qualified. I should have been the next in line for this position. I didn't get it. Someone else got it. And I think I have an idea why that other person got it. It's because of something discriminatory. Now, the question in this case, writes the Supreme Court, is whether to satisfy that burden, prima facie burden, which is like checking the boxes. Did you just check the boxes? If you check these boxes, then you're good. Now, does a white woman, is that standard applicable to a straight white woman, is what we're asking. A plaintiff, here's the question. Does a plaintiff, though, who is a member of a majority group, are they treated differently? Do they also have to show an additional checkbox? Okay, so like this is if you're a minority, you got to check those two. But if you're a white majority, you got to check all three. So the lower level judges inserted this one. They said, you also must show background circumstances to support the suspicion that the defendant, in this case, the white woman, is that unusual employer or the employer, that it is unusual employer who discriminates against the majority. Now, we hold that this additional background circumstances, so does the white person have to prove additional facts to support the suspicion that the company is that unusual employer who discriminates against the majority, which is a weird phrasing. Like, what kind of a sentence is that? That the employer is the unusual employer who discriminates against the majority. So I guess the burden, like, so the presumption in that kind of baked in there is that an employer doesn't discriminate. And so you have to overcome the presumption. So it's very hard for you to do that. It's like, well, most employers don't discriminate. You're white. Since most employers don't discriminate, you have to overcome the fact that they don't discriminate. So that's like a serious hurdle. Now, they say, no. Where'd that come from? We hold that that requirement is not consistent with the law or our case law, just made up by some judge that construes the statute. And so accordingly, we vacate that judgment and we remand, and this case must go back, and you just got to apply those two factors. You can't just say all white people also have to fill this one out because they're white. Now, the Ohio Department of Youth Services, some background on this and how this whole thing went down and works. They operate the juvenile correctional system. Now, in 2004, the agency hired the petitioner. Her name is Marlene Ames. We saw she's white. Confirmed. She's also heterosexual. Oh my gosh. To serve as an executive secretary. Now, Ames, that was in 2004. Lots changed since then. All right. No one, white women, straight white women, it's like, okay, you had your time. Now, Ames was eventually promoted to the program administrator, and in 2019, she applied for the newly created management position in the agency's Office of Quality and Improvement. Now, although the agency interviewed her for the position, it ultimately hired a different candidate. Oh no, a lesbian woman to fill the role. She's like, I've been here since 2004. You hire Kareen all of a sudden? Now, a few days after Ames interviewed for the management position, guess what happened? Her supervisors also removed her from her role as the program administrator. She also got demoted. She accepted a demotion to the secretarial role that she had held when she first joined the agency, and that resulted in a significant pay cut. Now, the agency then hired a gay man. Oh, a gay man to replace a straight white woman. Yeah, for diversity, it's like the whole agency is going to perform so much better now because they got a lesbian and a gay man up here. Everything's going to be perfect now. No one's going to be late to work anymore. No one's going to leave food in the microwave. Everyone's going to clean out their garbage at the end of the day. Wow, progress. Now, Ames subsequently filed this lawsuit against the agency under Title VII. They said, what? This is ridiculous. I was entitled to this management promotion, and I got demoted instead because I'm a straight white woman. Now, the district court granted summary judgment to the agency. They said, oh, gosh, you're complaining about this and you're a white person. Get out. So they found against her. The court analyzed Ames's claim under another case in 1973. And that establishes a framework, right? That gives us some checkboxes to evaluate. What is disparate treatment? How does it work? What is circumstantial evidence? What is good enough to prove that the gay man was better qualified or not better qualified than you? Now, at the first step of that framework, the plaintiff must make a prima facie showing that the defendant acted with a discriminatory motive. Okay, so checkbox 1, discriminatory motive is what we've got. So we're asking ourselves, do you check those boxes? Now, relying on the circuit precedent, the district court concluded that Ames had failed to make that showing. She had not suggested evidence of background circumstances, suggesting that the agency was the rare employer who discriminates against members of a majority group. He's like, they don't. Most employers discriminate against minority groups, so it must be rare. If you're a majority, then the likelihood of your claim being true is less, because he calls it rare. Now, without that evidence, the court held, plaintiffs who are members of a majority, white, including heterosexuals like Ames, could not discharge their evidentiary burden at the first step of the McDonnell-Douglas inquiry. Now, the Sixth Circuit affirmed this. They didn't care either. And a lot of this is actually being around her heterosexuality. We're not seeing much race in here, but she just happens to be white as well. Now, the Sixth Circuit affirmed, like the lower level court, they said, well, she's white. I mean, if she was a woman and black, this would be a different conversation, right? So the whiteness matters. They're not saying it, but it definitely matters. If she was a woman in any other color, then she would have not been in the majority. So they don't want to say white here, but that's what they're talking about. Now, the Sixth Circuit affirmed, like because if they said white, that's going to be like really bad. They're like, well, it's not a majority. That means white. Now, like the district court, the Sixth Circuit held that Ames had failed to meet her burden because she had not shown any background circumstances to support the suspicion that the defendant is the unusual employer who discriminates against you. It's like, well, that would never happen. So you have to really convince us that it did. Now, the court reasoned that Ames, as a straight woman, was required to make this showing in addition to the usual ones for a regular case, right? So she gets an extra checkbox because of her white privilege. Yeah. Here, you have some extra things you have to do in order for your claim to be valid. Enjoy it. Now, and it explained that plaintiffs can typically satisfy this burden where applicable by presenting evidence that a member of the relevant minority group, here gay people, made the employment decision at issue or with statistical evidence showing a pattern of discrimination. All right, so you got to show us that the gays have taken over against you. The gays have taken over against the straights. Now, the panel concluded that the agency was entitled to summary judgment, gays win, because Ames had failed to present either type of evidence. So what? Maybe you just are terrible at your job. Gays are much more whatever. And so Judge Kethledge concurred in the court's decision and wrote separately to express his disagreement with the background circumstances rule. So what? Where the hell did that come from? In his view, the requirement was not only unworkable, in that it required an assessment of evidence presented by different plaintiffs under different standards, but it's not even in the law. The Judge Kethledge's like, what? It diverges substantially from the text. It's not even in there. Can't just make this stuff up. Now, the Sixth Circuit decision reinforced a circuit split as to whether the majority group plaintiffs are subject to a different evidentiary burden than minority group plaintiffs at the first step. And so the Supreme Court says, we granted this case to hear about it. And here's more. They say the disparate treatment provision, SCOTUS writing, Ketanji, it stops employers from intentionally discriminating against their employees. There's a 3-step burden shifting framework for how this works. And burden shifting, we've talked a lot about lately. One side has to generate evidence to kind of push it over the line. And once that's done, then the other side can overcome that burden, or the burden shifts to them to rebut that and push it back over the line. So in McDonnell versus Douglas, we got a 3-step process for this. At the first step is familiar. The plaintiff, the white woman, has the initial burden of establishing a case by producing enough evidence to support discriminatory motive. If they clear that burden, then it shifts to the employer to articulate some other non-discriminatory reason for why that person was rejected. Now, finally then, right, so she says, oh, it looks discriminatory, kicks it to them. Oh, great, she met her burden. Then they say it's not discriminatory. They kick it back. And finally, if the employer articulates a justification, then the plaintiff has a fair opportunity to show that that was a pretext, okay? No, you just You were late a couple times. So whatever. No, it's not because I was late. It's because I'm straight. Now, a plaintiff may succeed in this by directly persuading the court that a discriminatory reason more likely than not motivated the decision. Now, for most plaintiffs, the first step of the framework is not onerous. It's pretty simple, unless you're white. A plaintiff may satisfy it by simply presenting evidence that she applied for an available position for which she was qualified but was rejected, which gives rise to an inference of unlawful discrimination. It's like super low standard. What kind of inference? What do you need to prove? What's the evidentiary standard there? But under Sixth Circuit precedent, plaintiffs who are members of a majority group bear an additional burden at step one. They must also establish that background circumstances support the suspicion that the defendant is that unusual employer who discriminates against the majority, right? That's that extra checkbox. Now, as outlined below, the Sixth Circuit's background circumstances rule cannot be squared with the actual text in the law. It's pretty clear. It doesn't say that, so you can't say that it does. They go through, they give us some background on this, a lot of precedent talk here, and more case law stuff. But let's see what the analysis is. They write, Ohio barely contests any of that at all. They know what the rules are. In fact, at oral argument, their state repeatedly acknowledged that this provision imposes the same burdens on a majority group as minorities. Now, its brief likewise offers no justification. Why would we have a heightened standard for white people? They can't answer it. Instead, the state came back. They tried to attack the premise of the question, presented by arguing that the background circumstances rule does not operate to subject them to a heightened standard at all. They say, so what if they have to do that? It's just another way of asking about the same thing that we're allowed to ask about. They say, no, it is not, the Supreme Court writes. This contention is directly at odds with the Court of Appeals' description of background circumstances. The Court of Appeals explicitly held that Ames is heterosexual, which means that she must make a showing in addition to the usual ones, right? So don't act like that's not how you were interpreting this. She was straight and white, so that is not qualifying for the minority benefits. So instead, it's in addition to. That's what the Court of Appeals said. And the ensuing passage of the court's opinion confirmed, yeah, it is a higher evidentiary standard because she's straight. The court also stated whether Ames made the necessary showing of background circumstances is the principal issue here because otherwise Ames' case was easy to make. The court then recounted. They said, well, she was qualified. She had been denied a promotion in favor of a gay candidate who was then later demoted in favor of another gay candidate. She got replaced by a gay and then actually went down lower. Evidence that would ordinarily satisfy this is right there. Right? She got demoted and another gay man got the job. Before it specifically faulted Ames, she says, well, you can't show that there's any background circumstances, like how that's abusive to you at all. They say ridiculous. In short, the Sixth Circuit expressly based its holding on the fact that she didn't meet the additional white checkbox. Ohio's attempt to recast this rule misses the mark by a mile. Ketanji says this. Well, Ohio also urges this court to affirm the judgment. They say, well, we got alternative grounds. But those alternative grounds would not require us to resolve these issues that the Court of Appeals did not address. We granted review. We leave it to the courts below to figure out if this all still applies based on the other factors. But you can't add in that third one. Now, the Sixth Circuit has implemented a rule that requires certain plaintiffs, those who are members of majority groups, to satisfy a heightened standard. But we conclude that that law does not impose that heightened standard on white or straight people. Therefore, the judgment below is vacated and the case remanded for an application under the proper standard. So ordered by Ketanji, and we've got concurring opinions from Justice Clarence Thomas and Judge Gorsuch, both writing. Justice Thomas Clarence, who's coming up on a record for the longest sitting judge on the Supreme Court, he says, I join the court's opinion in full. Much more baritone than that. I write separately to highlight the problems that arise when judges create atextual legal rules and frameworks. Thomas says, Judge-made doctrines have a tendency to distort the underlying law and text, impose unnecessary burdens on litigants, and cause confusion for the courts. And this rule, the background circumstances rule, correctly rejected by the court today, is one example of this phenomenon. And the decision below involves another example. In fact, the Sixth Circuit also analyzed the claim under a three-step framework, but that three-step framework lacks any basis in the law. So that framework is also bad. You guys just made that up too. Just like you made that first check, the final checkbox you said was bad. So are the first two, says Clarence. It's not in the law. He says, in a case, we can't even interpret what these things say because it is kind of a weird rule. It's like you prove it, then they prove it, and you can overcome the proving. Now, in a case where the parties ask us to do so, I would be willing to consider whether this framework is workable or even useful. So Clarence is like, come on back on this. We'll get rid of the other checkboxes too. Now, the Sixth Circuit's background rule is imposing a heightened standard on majority groups. White people have to prove more. Straight people have to prove more. The rule requires a majority group to prove, in addition to the other elements, background circumstances. Now, this additional requirement, writes Clarence, is a paradigmatic example of how judge-made doctrines can distort the law. Now, as the court opinion explains, there's no basis for that checkbox anywhere. It says there is any discrimination against any individual, and so that little rule plainly contravenes the law. It imposes a higher burden on some individuals based on the fact that they're white or straight. Now, this rule is a product of improper judicial making, and Clarence Thomas does not like when that happens. In support of this proposition, the court also made a mistake in relying on the framework in McDouglas. And the rule here, the court is even kind of admitting, like if you add checkboxes to things, that's a problem. So why do we add the other first two? Because courts lack an underlying legal authority on which to ground their analysis, says Clarence, there is no principled way to resolve these ambiguities. The background circumstances suffer from this flaw as well. Now, how a court defines the boundaries of a population can affect whether a particular person falls into a majority or a minority group, right? He who can draw the Venn diagram gets to separate the people. Women, for example, makes up the majority of the United States as a whole, but not in some states and not in some counties. So is a white woman in some counties maybe the minority in that county? I don't know. Similarly, women make up the majority of employees in certain industries like teaching, nursing, but the minority in other industries like construction. So do you want to do it by profession? Do you want whatever's most convenient for them, obviously. So when you start defining majority and you say, well, you're white. Okay. It's even more difficult in the context of race because racial categories tend to be overbroad. Now, American families have also become increasingly multicultural, and attempts to divide us up into a handful of groups have become incoherent over time. But they will not stop that. That's their entire game, right? Everybody's like a trading card. They're trying to create a full house. They got 3 gays, 2 blacks, and 5 trannies. Like, oh, great. We're going to winning hand here, and we're going to win elections over that. Like, it's their whole game. Now, and even if courts could identify all the relevant racial groups and their boundaries, courts would still struggle to determine which racial groups even make up a majority. Black employees in Detroit, for example, make up a majority in their city, but not in Michigan or the United States at large. So what is a minority? What is a majority? Similar problems arise with religion. Now, as with sex and race, says Clarence Thomas, a particular religion could make up the majority or the minority, depending on how the population is defined. He gives us a footnote about Asians too. He says, the term Asian, for example, is also extremely broad. Masks all the different countries of origin. It's very complicated. So when you're talking about background circumstances, and now requires courts to decide whether someone's religion or whether their religion compares with everyone else, can religion count to make you a minority? Those tasks are formidable. Americans hold wide ranges of views. And Americans have different views on whether Catholics or Christians. What? We are. The judicial process is singularly ill-equipped to resolve these kinds of faith-based differences. Courts that have adopted the background circumstances rule have offered no guidance on how to decide whether a particular person is a member of the majority. Instead, judges have been left to their own devices to make this stuff up. Now, most courts here, says Clarence, have appeared to sidestep these difficulties. The 10th Circuit, for example, assumed that the rule applies to white plaintiffs on the ground that white individuals are members of a historically favored group. Yeah, you got too much privilege. Get out of here. Similarly, the DC Circuit applied the rule to a white plaintiff while acknowledging, well, of course whites are in the minority in the District of Columbia, said some judge. Of course. Now, in other words, courts with this rule have enshrined into anti-discrimination laws explicitly race-based preferences. White plaintiffs must prove the existence of background circumstances, while non-white plaintiffs need not do so. Shout out to Clarence Thomas, the only dude who will say white, all right, in any of this stuff. It's true. Now, such a rule is undoubtedly contrary to Title VII, likely violates the Constitution. There can be no such thing as a race problem. Now, today, thankfully, today's decision obviates the needs for courts to engage in the sordid business of divvying us up by race or any other protected trait. Like, exactly right. Trading cards. That's what they do. Oh, you're a gay, you're a T, you're an L, come over here. And they just want to collect everybody. Stop it. We're Americans. We have that in common. Stop it. Now, I simply observe that the background circumstances rule is emblematic of the serious challenges that can arise when judges invent atextual requirements. And for too long, that rule is scratching the is putting a deep scratch across the surface, and I am pleased the court rejects that today. Now, this case involves a second judge-made rule, which is also applying that framework. Now, you assume, without deciding, the court is saying that we're going to continue this framework that I think is bad. And in the appropriate case, we should consider whether we're going to nuke that case too, but not now. He goes through the frameworks. He said it was made up out of whole cloth. They just made it up. Its contours have no basis in the law, in any other source of law. Clarence says, as far as I can tell, this court never even attempted to justify it on textual grounds. They just made it up, which is ridiculous, right? Like, if the law says, here's how to resolve these conflicts, then great, follow the law. It says, oh, they prove first and they prove second, and here's a way to resolve it. That's not what it says. The courts just said, this is how we think it should solve. Now, the doctrine framework exemplifies how judge-made doctrines can have amorphous bounds, writes Clarence. This was originally designed for bench trials, but today it has gotten way broader. And so we should not be extending this framework to new concepts. In fact, we should be limiting it. And the next time a case comes up here, it should happen. And Thomas continues, lots of problems with this framework, man. He's not happy about it. It requires that a plaintiff do a bunch of things, but it's a problem, right? Another problem and another problem. He says courts have no occasion to distinguish between what's actually happening in the case, and this has befuddled everybody since the beginning, and so it's time to end. That those who have carefully grappled with this framework for decades, they've been trying to figure it out for generations now, as he just listed, and they still can't make sense of it. You know what that means? The framework is unworkable and it needs to go. So this case did not present the question of whether we should nuke McDonnell Douglas, but in the meantime, litigants in lower courts are free to proceed without it. This court has never required anyone to use it, says Clarence Thomas. So Clarence is saying, hey, you can also just get rid of it. And the district courts are well equipped to resolve summary judgment without it. You've got cover from Clarence Thomas and Judge Gorsuch now saying, yeah, you don't need to actually follow those rules. Atextual judge-created legal rules, writes Clarence, have a tendency to generate complexity, confusion, and erroneous results, and I am pleased the court today rejects the white checkbox for straight white women, saying you got to show you deserve it before there can be any recourse for you. So, very nice decision from the Supreme Court of the United States. Major victory for the country. Weird how judges continually manufacture new requirements against litigants that they don't like. But it was a victory for this woman, and congratulations to Marlene Ames out of Akron, Ohio, for having success at the Supreme Court. Unanimous decision. Ketanji, Kagan, and Sotomayor all coming in. We don't want additional standards imposed based on skin color, sexuality, or any other characteristics that are inappropriate, and the Supreme Court is in agreement. So we're happy to see that. Congratulations there. We'll keep our eye on SCOTUS and see what comes next. Speaking of what's coming next, boom boom sticks. Let's talk about this one before we jump into the spitting lib and see what is happening in that case. Here's what's coming up next in the Supreme Court. Victory for the Second Amendment coming from the Supreme Court. And we're excited about this one because we had a not so good case come down previously where they kind of kicked the can down the road. They didn't want to hear an issue about whether AR-15s were common and in widespread use. And so they punted that. And we were here reading through it and we said that's very interesting because remember Judge Kavanaugh came out and said, what we can intimate here is that if these are, in fact, found to be widespread and in common use, then that would make it traditional, meaning that we cannot regulate it. It's something that would be analogous to how things were during the founding era, which would mean those regulations cannot stand, and states are starting to regulate those things. And Kavanaugh said, we'll come back to it, but when is the question, because justice delayed is justice denied. But this case is Smith and Wesson, and the lawsuit was brought by the government of Mexico. They sued Smith and Wesson. And the Supreme Court came back down and issued a ruling. And so let's go through the full opinion, shall we? Rather than just the syllabus and the head note, which is what we just fast forwarded through. Now, here is the case. In the Supreme Court of the United States of America, Smith and Wesson victorious, and this decision coming from Justice Kagan, liberal judge, who's going to give us some very helpful language in the ongoing Second Amendment fight. They write the following. The government of Mexico brought this lawsuit against 7 American gun manufacturers. The Mexicans are suing our gun makers? As required by a federal statute, Mexico seeks to show, among other things, that the defendant companies participated in the unlawful sale or marketing of firearms. I mean, it's surprising that Mexico is going to lose this because we know how much rights all these foreigners have been getting over these judges lately. But here we go. Now, more specifically, Mexico says that the companies aided and abetted unlawful sales routing guns to the Mexican drug cartels. I thought that was Eric Holder who did that. This question presented is whether Mexico's complaint plausibly pleads that conduct, and we say it does not. So Mexico, you lose. And gun manufacturers are going to be insulated from any liability from foreign governments. They write, the Protection of Lawful Commerce and Arms Act bars certain lawsuits against manufacturers and sellers of firearms. Congress enacted the statute in response to a spate of litigation, people suing the gun companies, trying to hold them liable. They said, well, somebody used your gun to kill somebody, and so you're responsible for manufacturing the thing. The Act's definition said that's not how any of this works. But the Act and the general bar on those suits has an exception, right? The companies are insulated from some litigation, but there can be exceptions. Now, that exception applies to suits in which the defendant manufacturer knowingly violated a law. If someone can sue and say, well, it looks like the manufacturer knowingly violated a law and then the gun caused harm, they can be liable for that, even if it's a third party who did the harm. Now, or otherwise, the predicate violation can open a path to making a gun manufacturer civilly liable for the way a third party has used the weapon it made. So if you're breaking the law and doing things illegally with firearms, you're responsible for the harm that results in the aftermath of that illegality. Now, notably here, the predicate violation, what did the gun companies do illegally, that it demands it may come from aiding and abetting someone else's firearm offense. Now, the predicate exception itself lists 2 examples, ways in which aiding and abetting can be the thing, see the law, and more broadly, it's talking about assimilating accomplice liability, and the federal statute says whoever aids and abets the commission of a crime can be charged as a principal. So if your gun is used in a bad way by a bad person, and you were breaking the law to kind of help in that, you can be liable as well. Now, here's what Mexico says. Mexico has a severe gun violence problem. and they want us to have that now, which its government views as coming from north of the border because it's our fault. Now, the country has only a single gun store, and they issue fewer than 50 gun permits each year. That's weird. Well, how come they have guns then? I thought gun control, if you just ban the guns and issue permits, that suddenly no one has guns. How did that work? But gun traffickers can purchase firearms in the United States, often in illegal transactions, and deliver them to drug cartels in Mexico. You know what Mexico needs? A wall. Yeah, they should build a wall to stop our guns from going down there, to stop their gun crime down there. Yeah, they should start building it right now. They can start on one end, we'll start on the other. Those groups, predictably enough, use the imported firearms to commit serious crimes like drug dealing, kidnapping, murder, and others. And the Mexican government, as much as 90% of the guns recovered from the crime scenes, came from the U.S. Now, the Mexican government, seeking redress for this gun violence, sued 7 American gun makers. Foreign country, just, oh, Smith & Wesson, you're now sued. The lawsuit, brought in a federal court, asserts a variety of tort claims against the gun makers, mostly sounding in negligence. Now, the basic theory is that the defendants, the gun makers, failed to exercise, quote, reasonable care to prevent their guns into Mexico. And they're responsible for the harms because someone bought their guns and shipped them to Mexico. It's almost like interstate commerce, except international commerce, and American companies are responsible for this. Now, that theory, as all agree, runs straight into the general prohibition here of the law. Mexico's action seeks to hold firearms manufacturers for criminal or unlawful misuse, and the law says that can't be brought. So then they try to plead its way into the exception. They say, well, we actually have a reason why we can sue here. It asserts, as that exception requires, that the third-party misuse of guns in Mexico resulted from their knowing violation of gun laws. Well, what is it? Specifically, the complaint by the gun makers says that the manufacturer's firearms violations were ones of aiding and abetting rather than independent commission. They say, according to Mexico, there were willful accessories in the unlawful gun sales, and they set out 3 kinds of allegations. Their primary argument is that the manufacturer gun suppliers supply firearms to retail dealers who they know illegally sell the guns. The complaint explains they use a 3-tier distribution system. Wholesale distributors sell to retailers, retailers sell to customers. A small minority of the dealers are responsible for most of the sale to the traffickers, and those violate federal laws. But still more, the complaint alleges that this is key, that the manufacturers know who those bad Apple dealers are. Who is giving the guns to the cartels? They all know, like, we don't know, don't ask, don't tell. But the manufacturer continues to supply those guns. And them not choosing to cut off the flow to the illegal dealers are making them intentional participants. Now, Mexico also claims that manufacturers have failed to impose any types of controls that would prevent illegal sales. They say a raft of ways of manufacturers could actually divert the guns into our markets, and they should take more responsibility to prevent this from happening. And third, Mexico says manufacturers make and design marketing decisions to create demand. They say, hey, gangbangers, hey, Tren de Aragua, you want to protect your pupusas? Come into our store. Get a 50 caliber long range sniper rifle. And anybody who's coming to Mama Cecilaria's Papusalilaria, you can protect yourself. Or for the gay barber, if you're concerned as you're going to the grocery store because people are looking at your outfit weird, why don't you come in, get a 38 caliber Super El Jefe pistol. El Jefe. Or Super El Grito pistol. Or Emiliano Zapata 1911 pistol. It is better to die standing than to live on your knees. That is absolutely right. That is absolutely true. So they're creating it to appeal to the Latinxes. Now, the defendant manufacturers moved to dismiss the complaint. Gun makers, like, get out. The district court granted the motion by the Court of Appeals for the First Circuit reversed, said Mexico can sue. Of course, it found that Mexico's complaint said, well, they might be aiding and abetting these gangbangers. Now, as a result, Mexico's suit could go forward. Now, the complaint survives only if there is an exception. And because Mexico relies exclusively on this aiding and abetting theory as to the proximate harm, we do not need to address that question. about causation, and Mexico has not met the bar. Its complaint does not plausibly allege the kind of conscious, culpable participation in another's wrongdoing, right? So we talk a lot about, different things you have to prove, like a guilty mind, mens rea, a guilty act, actus reus. And then you've got causation, right? If you did an act, what are the necessary consequences of that act? And how far downstream do they go? If you bump into somebody and they drop their groceries and the egg rolls down and somebody steps on the egg and then they crack their head open, are you responsible for bumping the person who dropped the egg that someone stepped on that cracked their head open? Are you responsible for that injury? Oh, you would say, no way, I have no responsibility. Like, this is just a random world. The guy who got his head cracked open would say, you caused this, you started the whole thing. So the same thing is here. They don't need to go down the causation route. They just say, first of all, you can't say that the manufacturers had any conscious knowledge that they're aiding and abetting, and so your argument fails there. Saying federal aiding and abetting laws reflect a century-old view of culpability, that a person may be responsible for a crime he's not personally carried out if he deliberately helps another commit the crime. They go through the cases that explain this type of liability and other cases where they haven't. Now, when you view all of this against that legal backdrop, they say Mexico's complaint does not plausibly allege that there was any aiding and abetting. And we have little doubt that, as the complaint asserts, that, yeah, there are some sales that take place, no doubt, and that the manufacturers know they do. Like, they know that those are being sold. Like, they can't, once it's out of our hands, it's out of our hands. But still, Mexico has not actually said that they're participating in those sales or that they wish to bring those about or that they're taking action to make those succeed. In fact, to begin with, Mexico's lawsuit sets for itself a high bar. The complaint does not even pinpoint, as most aiding and abetting claims do, any specific criminal transactions that they allegedly assisted. Can you show us one where we assisted? Can you show us one? No. It does not say, for example, that a given manufacturer aided a given firearms dealer at a particular time and place in selling guns to the given Mexican trafficker who's not legally permitted to buy them. Instead, the complaint levels a more general accusation. It says, all manufacturers assist some number of unidentified rogue gun dealers in violation of the law. And that systemic nature of that charge is not necessarily fatal, but as noted earlier, it cannot help but heighten Mexico's burden. So, to survive, you've got to give us something more substantial. Their lead claim is that the manufacturers elect to sell guns that are going to known rogue dealers. But that doesn't mean enough either. It doesn't meet the standard. Direct sales is the case that Mexico is relying on, but that case was more particularized than this one, and it just doesn't apply. Their complaint asserts nothing similar to that case. In fact, it's opposite. Their complaint repeatedly states that the manufacturers treat rogue dealers just as the same as they do law-abiding ones. They sell to everyone on equivalent terms. In other words, they're not giving anyone any other benefits. So even your complaint would stretch the bounds of our case law. But in any event, we cannot take the allegation here at face value because Mexico is not said enough to make it plausible. In asserting that the manufacturer's intention to supply guns to bad dealers, Mexico never confronts that the manufacturers do not directly supply any dealers, bad apples or otherwise. They sell firearms instead to middleman distributors whom Mexico has never claimed lack independence. So basically the causation is broken at that moment. Now, given that industry structure, Mexico's complaint must offer some reason to believe that they want the guns to go down to the bad people 2 levels down. But it doesn't even address that. And even assuming that the manufacturers know everything that the distributors know, the complaint would still not adequately support the charge that they've identified the bad dealers. Mexico doesn't even name those dealers, though they are ostensible principals in the transaction. Like, they probably exist, but name them. Mexico doesn't even provide grounds for thinking that anyone up the supply chain even has that information. Instead, the complaint points out that government agencies only sporadically provide information, and so there's not enough here. What Mexico has plausibly pleaded, respecting sales to offenders, is a lesser wrong, which is not good, but it doesn't rise to the level of aiding and abetting. Come on. Mexico's complaint alleges that some dealers do get illegal guns, And so too, the complaint says that manufacturers know that's true. Yeah. And finally, the complaint says with sufficient plausibility that they could do more to figure out who they are and cut off their supply. That's probably true. It's all probably true. It's not aiding and abetting, but that is to say little more than what they said in another case. And according to the complaint in that case, bad actors is more, it requires more. Now, Mexico's second set of allegations says that the manufacturers have decided to not regulate their practices. But just because they're not doing something you want them to do doesn't mean they're aiding and abetting. Now, all of that means that the law prevents Mexico's lawsuit from going forward. The allegations they're making do not fit into the exception. It permits, the exception only permits a lawsuit to be brought if they're aiding and abetting. Mexico has not been able to prove that. And so we therefore reverse the judgment of the court and remand the case for further proceedings consistent with this opinion. So major victory for the gun manufacturers. We've got Justice Thomas again concurring in the judgment. Clarence Thomas joins in. The court today correctly decides that Mexico has not plausibly pleaded that its suits fall under the predicate exception of the law. This exception allows otherwise prohibited suits against gun manufacturers to go forward if, among other requirements, the manufacturer knowingly violated the law. Now, I write separately, says Clarence Thomas, to note that the court's opinion does not resolve what a plaintiff must show to establish a violation. It concludes only that Mexico has not adequately pleaded its case. That is a factual matter. The gun manufacturers committed criminal aiding and abetting. It's like they haven't met the standard, but what is the standard? In future cases, courts should more fully examine the meaning of violation. It seems to me, Clarence Thomas, that the law at least arguably requires not only a plausible allegation that they've committed a violation, but also an earlier finding of guilt and adjudication regarding the violation. So Clarence says, actually, like the gun manufacturers deserve way more protection. You can't even sue if it's an allegation of wrongdoing. You got to have a violation. So like they got to be prosecuted for it. Allowing plaintiffs to proffer mere allegations as a predicate violation would force these manufacturers to litigate their criminal guilt in a civil proceeding. That's not what the law says. Without the full panoply of protections that we otherwise afford to criminal defendants. And these defendants might even include ones who were cleared in earlier proceedings just because someone else made an allegation. So we cannot allow these collateral adjudications. One case over here, one case over here. That would be serious constitutional problems. And this warrants careful consideration. Now, Ketanji is also joining in. She's concurring in this. The Court of Appeal says the court holds that Mexico's complaint is bad. I agree. I write separately to explain the complaint's core flaw is its failure to allege any non-conclusory statutory violations in the first place. Kind of sounds like she agrees with Thomas. Says this was in response, this law was passed in response to Congress's flood of civil lawsuits against gun companies. They said you can't do that. Viewed in light of this inclusion of this, the exception makes perfect sense. They got to violate the law, and the exception might be triggered under aiding and abetting, but all Mexico has done here is say that the firearms industry is causing unspecified downstream violations. And so Ketanji says it is for these reasons that I view Mexico's allegations as insufficient, devoid of any non-conclusory allegations about any violations. Mexico's lawsuit seeks to turn the courts into common law regulators. It's probably what they're used to down in Mexico. But Congress passed PLCAA to preserve the primacy of the political branches in deciding duties to impose on the firearms industry. Construing this exception to authorize lawsuits like Mexico brought would distort the basic design. Yeah, so go back to the drawing board there, Mexican lawyers, because this was a terrible filing. The Supreme Court says you haven't even made any allegations. And even Ketanji's on this one. Things don't work like they do in the United States, like they do in Mexico. Okay, we have courts, we have laws, and we're following them. So if you don't want guns in your country, why don't you help us build a wall? And why don't you do something about your drug cartels, who are the ones who are coming and buying the guns? We want a wall. We could have you help us build it. Help us help you. Mexico, por favor. All right, so we'll keep our eye on that one, but a big victory for the gun case. All right, so now, my friends, it's time for this woman. The spitting lib is back in more trouble. She's already been charged with a crime for spitting on Ed Martin, hawking a loogie on him like a demented lunatic. And now she is in more trouble because she's been posting on social media against Ed Martin, and her release conditions say she can't do that. And if you violate your release conditions and you're out on release, you know what that means? You go back into custody. And the DOJ has submitted a motion to make that happen. It came here, says the government has now filed a motion for revocation of the conditions of release. And so she should be going back into custody, says the DOJ, writing that the United States of America, by and through its attorney, now hereby move for the revocation of her release conditions for Emily Gabriella Summers, the woman seen here loogieing all over Ed Martin. Time to go back into custody. Here's why. On May 8th, 2025, we recall, at approximately 3:30 p.m., the day of the loogie attack, in front of Northwest Washington, Ed Martin, who is hereinafter going to be referred to as Victim Ed, was conducting a video recorded interview with Newsmax Television. At the time, Victim 1 was the interim U.S. attorney for the District of Columbia. Now, during the interview, Suspect 1, later identified as Emily Gabriella Summer, approached Victim 1 and came up to Ed Martin and stated words to the effect of, "Who the F are you?" She turned, and Ed turned to face her, and then Summer said the words of something to the effect of, "Are you Ed Martin? You are Ed Martin." Next, Summer lunged at Ed and spit on his left shoulder. She then walked eastbound and yelled, "You're a disgusting man. F you, Ed Martin. My name is Emily Gabriella Summer, and you are served." So investigators queried the name Emily Gabriella Summer in law enforcement databases. They identified her. They also learned that she is associated with address number 1. They showed an employee at address number 1 a still image of video footage from the incident. You know this one? The employee said, "Oh yeah, that's Summer. Oh yeah, she lives there at that address." So then investigators went on. They identified her X account, user Emily Gabriella S with a display name called Left Nipples, and determined that Summer is the account holder for that X account. And she's been going wild on it since. The Emily Gabriella S account also contains a profile picture that appears similar to known photographs of her. Okay, so Left Nipples, Emily Gabriella S, Emily. Thank you, Emily. There's her. What a peaceful person with a flower in her mouth. Now, moreover, records provided by X show that the account is associated with phone number 1. Law enforcement queried phone number 1 in a law enforcement database and learned that phone number 1 is associated with this woman. So then on May 8th, shortly after the assault, at 6:03 and 6:10, Emily and her account made several posts relating to the assault, right? We saw her post this before and watched it unfold. Ed Martin said, "Great people," talking about the narcotics team. And then Emily says, "Ed, that was me that spit in your face today in front of your not US DC for DC courthouse that absolutely definitely spit in your face on camera. Hi, hello, a pleasure to hawk a dehydrated pithy white foam spit into your face. I only apologize that this city left me so dehydrated and unable to get water that I couldn't produce more to stain and drip down your face." Poop emoji. Lunatic. Totally nuts. This city left me, right? That's how much of a victim this person is. Just listen to her language. This city left me so dehydrated. Yeah. Because you're just a passive actor in your life. Everything is happening to you. And you're not responsible for your own level of hydration. Pathetic. Take some ownership of your liquid consumption. Ed Martin, she also says, dropped the same thing. Remember, she was kind of copying and pasting these things. Ed Martin said, that happened. Such stories inside. Ed, that was me. I'm still dehydrated. I couldn't get water. I'm dying. So said the same thing again, right? Another one. Just copy and paste these things. City left me dying. Same one here. Now, we all saw those already, but there's more coming up. She was copying and pasting. She can't help herself. This was all before she was ultimately arrested, and she didn't have release conditions that said you can't do this. So then on May 22nd, she was arrested. She was charged by complaint with one count of assaulting an officer with a disgusting loogie, assaulting a federal agent employee. In the course of the arrest, she kicked and spit on one of the marshals and kicked another deputy United States Marshal. Man, those should be new charges. Dude, anybody else would get hit with resisting arrest, new assault charges. You can't spit on cops. They should be new assault charges for this U.S. Marshal, victim 2, and another deputy U.S. Marshal, victim 3. Should be charged for assault for 2 more people. Now, the government did not request pretrial detention, but she went nuts. And she was released subject to conditions under the law. Now, one of the conditions imposed by this court requires her that the defendant avoid all contact, directly or indirectly, with any person who is or may be a victim. You definitely cannot contact a victim, all right, at all. Happens all the time in criminal law. A lot of domestic violence cases. Well, can she come home now, or can I come home to her? No, right? Not unless you negotiate that out. You don't get to just contact victims of your crimes. So maybe a victim or witness in the investigation, including Ed Martin. And I pulled up the release conditions here so we can take a look at them just to confirm it. But here you see it out of the U.S. District Court, District of Columbia, 4 pages. Case against Emily Gabriella Summer, the Loogie Emily. She is now ordered. Don't violate any law. You must cooperate with a DNA sample. You must advise the court before making a change to your number or address. You must appear back in court June 10th at 1 p.m. in front of Magistrate Judge Zia Faruqi. And you must sign this paperwork. Now, this defendant is not being held in custody, right? That was not requested. That is going to change now. Now we're saying, actually, we're going to want that box checked, and we want her to go into custody. Here's why. She violated these rules. The defendant, via court order, must submit to supervision and report for the supervision by pretrial services. Okay, pretty standard stuff. Got to check in with somebody, call them. They'll have a program, so you check in. Doesn't say anything about employment, not anything about education. Give up your passport. Do not get a new passport. You must abide by the following restrictions. You should notify the pretrial services agency if you're leaving the metro area. So if you're going to leave this location, let us know. Court to approve all travel outside of the continental United States. Now, check box G. Checked. Avoid all contact, directly or indirectly, with any person who is or may be a victim in this prosecution, including Ed Martin, the victim of the crime. So what's going to happen when she contacts him? She also needs to get medical or psychiatric treatment. Yeah, good call on that one, Judge. Definitely. Report to PSA for a mental health assessment. Participate in mental health treatment as directed by the PSA. So she might be crazy. If they say she's crazy, then they'll get some health treatment for her, but she's got to at least do an assessment to make that determination. So similarly, Doesn't have to report back to custody. Sometimes this would be like work release, like you got to go, you're free to go to work from 8 to 5, but come back in and sleep in the jails. You are not allowed to possess a firearm. Do not use alcohol at all. Do not possess any narcotic drugs or controlled substances. Submit to testing for substances, urine testing, sweat patch, alcohol testing, whatever they order. And that's it. No home monitoring, no home incarceration, no home detention, no curfew, none of that now. No GPS, no checking of monitoring technology or anything like that. Report as soon as possible to pretrial services or any contact with law enforcement. Verify your address, comply with all rules, refrain from marijuana usage, including medical marijuana. This is a federal court. Contact PSA via telephone to conduct your interview. Stay away from Main Justice. You're not allowed to go there to that building. You must sign all release of information forms, okay? So they've got her signature on this somewhere, and you shall be placed into your specialized supervision team. And writing the following. You are advised, Emily Luggie, if you violate any of these conditions of release, that may result in the immediate issuance of a warrant for your arrest. It could result in the revocation of your release. We could order you detained. We could forfeit your bond. And we could prosecute you for contempt of court that results in imprisonment, a fine, or both. Now, while on release, if you commit another felony offense, that's going to make things way worse. Don't commit another crime if you're on release for a current crime. Everything gets worse. And you're non-bondable. This sentence will be consecutive in addition to any other sentence you receive. So you get like years, like 5 years for this one, 5 years for the next one, not running concurrently, one after the other. Not 5 years and 5 years starting at the same time. 5 years, you're done, start the next 5. It's a crime punishable by up to 10 years in prison, to obstruct a criminal investigation, to tamper with a witness or a victim, like Ed. The penalties for tampering, retaliation, or intimidation are significantly more serious if you're involving the unaliving of someone. Now, if after release, Emily, you knowingly fail to appear for your conditions of release, you may be prosecuted for failing to appear, a new crime, or surrender and additional punishment may be imposed. A term of imprisonment may also come to you if you don't show up. Emily, do you acknowledge that you understand these conditions of release? Yes, Your Honor. Do you promise to obey all conditions of release, to appear as directed, and to surrender to serve any sentence imposed? Yes, Your Honor. Are you aware of the penalties and the sanctions that I just described to you? Yes, Your Honor. So be it. Then we'll be back for our next court date at a later date and time. Acknowledged on the record by Emily. So she knew. Judge signed off on it. Matthew Sharbaugh confirming she knew what the order was, but she didn't care. On June 3rd, after she was arrested, after she was released, signed on the record, May 22nd, she posted on June 3rd. Had her court hearing, promised the judge wouldn't harass the victim, and here we go. On June 3rd, law enforcement observed that Emily Luggie made the following publicly viewable posts on X. She wrote, "Quite actually urgent request for assistance of any and all types. My property has essentially been seized, and I do not have the basic necessities nor money to provide for myself nor my dog. F you, Ed. But since you've once again made me hostage in this city, I'll make sure it eats you alive and spits you back out. Like the felony assault you've alleged with your punk-a bitch." Excuse me. There's so many bad words. I didn't mean to say that one. The BC, neo, no brain Neanderthal. Gosh. No shade to actual non-Sabians. What redneck from the Midwest? This lady went nuts. Then she tagged Eagle Ed, right? She might have said I was just talking about some random Ed, but no. Then she tagged him, "Hey, Eagle Ed Martin, you mad, bro? You got fired and then caught a loogie to the shoulder. I don't think that makes you any sort of active official. You're in the wrong court. You red-nosed, Rudolph, stumbling, bumbling alcoholic. You have quite literally no brain. Come at me, dog. Let's have a debate." And LMAO, Judge Janine is the bish that took your job. That's gotta hurt. And she's got so much trash talk coming her way too. Don't worry, Janine, you'll get it too. Oh, that sounds like a threat to me. And she's on release. She might be a crazy person, bona fide. There's a lot of crazy people out there. It's hard to tell because she also just sounds like a leftist who we hear a lot about. And this is how they think. A lot of them kind of will not say all these things like crack ass, jive turkey, redneck from the Midwest. But there's a lot in there. Yeah. So can't do that. You're on release. We just read the release conditions. That's a no-no. Now, as shown above, one post includes a mention of the victim, that's Ed, and includes language specifically at the victim. You mad, bro? You got fired and then caught a loogie. On X, a mention is a post that contains another person's username in the body of the post. When an X user makes a mention of another user, the mentioned user will generally see the post in the mentioned user's notification tab, right? It's a direct, you'll see it. Depending on the user's settings, a mention may also cause a user to receive a push notification. Pops up on Ed's phone. Oh my gosh, the loogie lady's attacking me. Another post includes language directed specifically at the victim. F you, Ed, I'll make sure Washington eats you alive and spits you back out like the felony assault you've alleged. Now, the release condition statements explain very clearly. Violating any of the foregoing conditions of release may result in the immediate issuance of a warrant, a revocation, an order of a detention, a forfeiture, and a prosecution of contempt. And so hereby, being requested from the DOJ is a request that Emily Loogie's bond and release be revoked. It says under the law, the court shall enter an order of revocation and detention if, after a hearing, the judicial officer finds that there is clear and convincing evidence that the person has violated any other condition of release and finds that the person is unlikely to abide by any condition or combination of conditions of release. And here, there is clear and convincing evidence that Emily Loogie violated a condition of release, specifically using the X account with the username Emily Gabriella. The defendant made direct digital contact with Ed by making posts that included a statement directed at Ed and mentioned his personal X account, which would likely cause the post to appear in post notifications tab of the victim's X account. The post therefore violated this court's order to avoid all contact directly or indirectly with the victim. Now, the account is attributed to her for several reasons. We know she did it. The username includes her first and middle names and last initial. It's got a profile picture. It's her. In addition, subscriber information for the X account includes a phone number that is separately linked to her in a law enforcement database. And as shown in the above post, the account user took credit for the charged assault shortly after the assault took place. So we know it's her. And so her conduct demonstrates that the defendant is unlikely, Emily Loogie, to abide by any conditions of release. And in particular, the charged assault and the subsequent assault on law enforcement officers demonstrate her unwillingness to abide by the law and to comply with lawful authorities. And by the way, as we mentioned, the government may also seek additional charges arising from her conduct, including additional counts for assaults on law enforcement officers and other spitting on them, and related offenses from the ongoing harassing conduct towards the victims. Yeah, 2 new victims, 2 new assault charges. Would happen to anybody else, right? You do that. You try to get arrested, see what happens to you. You start kicking and spitting at a cop, you're getting charged for that. So wherefore, the government respectfully requests that this court grant the government's motion to modify her release conditions and revoke her release conditions take her into custody and make sure this type of behavior is stopped. Signed by Jacob Green, Assistant U.S. Attorney, filing this puppy out in the District of Columbia in the case against Emily Gabriella Summer. We'll see. I mean, it's clearly a violation of the release conditions. You might see a judge come back and just say, you know, you're not supposed to tweet at him. No, I didn't know that. Okay, now you know. You do it again, you're going to go, you're going to go into custody. We'll see what the judge says. But the fact, she's got some other aggravating factors here. It's not like she just done goofed one time. It's and maybe the judge would give her the benefit of the doubt. She's kind of nuts. She attacked other people, spitting on the cops during the arrest. And so now she may be going back into custody. So we'll keep our eye on it. Let's see if there's any new filings that just dropped for us. Looks like she got a new attorney. Alexis Morgan Gardner is going to be her new attorney, appearing for Emily Gabriella Summer. Just got filed today. Okay, it's a public defender. So Alexis Morgan Gardner. Shout out to our public defenders out there. The public defender saying that we're assuming responsibility for this case. And so certainly they'll oppose that motion for revocation. Just an oversight. She didn't know. She'll promise not to release any more posts. Don't take her into custody, but we'll see what the judge does. And we'll cover this case to its fruition, most likely. Thank you for subscribing and joining as we do. All right, so my friends, it has been a beautiful and lovely stream. Thank you for hanging with us. If you're just joining us, quick recap on what we talked about today. We commented briefly at the start of the show on the Elon Trump political domestic violence situation that's brewing out there. And then we talked about the Supreme Court. At the Supreme Court, we had a major victory for a straight white woman. Shocking, I know. Marlene A. Ames, confirmed to be white right there. She was suing the Ohio Department of Youth Services, and she won. They said, if you're white, you got to prove additional circumstances to show that you were discriminated against. The Supreme Court said, actually, you don't, because that's racism. So how about no? Go back, hear the case again, apply the usual standards. Now, she might go down, right? This might go back down, and they might say, no, I mean, clearly it's not discrimination. You were just bad at your job or whatever. So she's not out of the woods on it yet, but very nice precedent set by the Supreme Court, which, of course, was unanimous and the way it should have been from the beginning. Now, we also then talked about the gun case. Smith & Wesson beat the crap out of Mexico. Mexico sued and said, how dare you have guns coming into our country after they invaded our country with 20 million people? And suddenly, they don't want bad things happening. We've encouraged them to build a wall for years now, and they don't want to do it. So instead, they want to sue our gun manufacturers. The Supreme Court said, no, you can't do that. Get out of here. Your case stinks. Your lawyers are terrible, and don't come back. So we saw that. Then we went through the spitting lib. Emily Hakalugi, she is now facing the prospect of going into custody because she keeps tweeting at Ed Martin. I'm kind of the mindset the judge might give her a break on it, but for the fact that she is violent and was assaulting other agents, U.S. Marshals, when they were arresting her. So we covered a bunch of good things today, my friends, but now it's time to hear from you. And we really appreciate you being here. Thanks for subscribing. Thanks for inviting a friend or family member to come over and join us when we go live. We appreciate seeing all of you here, and we appreciate your support on the show. And I see we got some great donos that came in, so thank you for sending these in. Thank you to K Bean, Donut, and our friends clipping for us today. It is a beautiful Thursday, man. Here's Elon on Rogan, just puffing away. We're not too worried about the Trump-Elon thing. Now, I don't know what's happened in the last 2 hours. They might have gotten worse, but who knows? Anyways, thank you for that, Ravicus. Hey, one can only hope that this is by design. The conflict between Elon and Trump, I can see it as laying a trap for Dems. Yeah, Democrats say, kill the bill and release the Epstein files. I'm like, okay, that's fine. Yeah, do it. They already took the bait, hook, line, and sinker. I think, yeah, I don't know if it's like, I don't think it's four-dimensional chess. I think there's some pretty bad blood there at the moment. But I don't see it as catastrophic, I think, like many other people currently do. Sergeant, it's not good. I'd rather them be working together, but we have to have some serious conversations in this country about spending and about these issues. And if we got to shake the cage loud enough that it's going to cause some uncomfortableness for Congress and for the positions that are currently in power, that's just how it's got to be. It's going to be uncomfortable. So just get used to it. Mom and dad are throwing pots and pans over there, but no one's bleeding yet. Sergeant GPS, who knew the Supreme Court would be the least controversial thing today? Gosh, I know. It's a wild day. It's just like, wow, every day, every like hour, it's like, oh, well, they're going to work it out. Oh, next tweet. Oh, space shuttle, space stations coming down, Epstein files. It's ridiculous. Knox Bierman, what's up? Hey, happy Thursday, all. This one could use some help. There's an 11-year-old with terminal inoperable brain tumor. I know her uncle, and here is the GoFundMe. Support Ellie's faith's fight against cancer, a brain tumor. So check that out. You can look that up. GoFundMe, Ellie Faith. Here is what it looks like. Beautiful family, man. They've raised some good money. Could use some more. Read more. Search this one out. Reaching out with heavy hearts. Beloved 6-year-old daughter recently diagnosed with a rare and aggressive brain tumor. So family could use your support over at GoFundMe. Support Ellie Faith's fight against DIPG. Thank you for sharing that, Knox. Gene Crane. The Democrats are getting played. Anything that Elon is against, the Democrats will be for. Yepers, they are being played. Well, the Democrats I think they just take the opposite side of, they have no principle or any real vision. So they just feel like skittish people who are just reacting to whatever feels politically expedient to them. Hey, Vienticus Prime! Remember our friend Vienticus? Mod the fort down for us some time ago. What's up, V? I see you're publishing a bunch of books over there. The Last Enchantress. Get your copies on local stores. Vienticus, just stopping by during some downtime to drop a hamaste. Bacon blessings be upon you and to you. Blessed be the bacon faithful. Know your grower. Yes, and get your fill of bacon. Thank you, Venticus. It's good. I do enjoy bacon. I've been eating less of it, but it is good. Hey, Doan, if Elon versus Trump is a PI gimmick, it's genius. If not, then I'm totally behind your historical qualification. Well said, too. Thank you, Doan. Yeah, I think it's not that big of a deal, personally. I think it's not good that they're fighting, but it's like, what's the ultimate downside? I think we win on both ends of the conflict. Like, we come out better, however it's resolved. And I'd rather have the conversation than not have it. So yeah, it's going to be tough, but it's tough. Like, I like them both. I'm very grateful for both of them a lot. And I'm not going to be caught in this thing where we have to pick one or the other and, pick a side or whatever. It's just like, look, man, I know these are complicated times. I get it. Emotions run high. Sometimes two dudes have to go out back and just beat the hell out of each other. But in the context of things, I think we're going to come out better for it. So thank you, Doan. Hey, Voice of the People. Hey, you're welcome for the ATOM plugin for OBS. It would make too much of an a-hole to not help a streamer with such an easy fix. Thank you, Voice of the People. I do appreciate your help. Thanks for flagging that for us. Friends, check out Voice of the People's podcast everywhere they stream. Hans, what's up? Elon Trump is theater. Elon needs left to stop firebombing Tesla and SpaceX. Trump needs Senate to pass the big, beautiful bill and remove all the waste. Yeah, I mean, first of all, I, in a way, agree with that. So that's just how Trump is, by the way. Like, you remember the whole thing with Megyn Kelly? That story arc came full circle. It took like 6 years or 8 years, whatever, but she tells the story. The blood coming out of her eyes were everything. Remember that? And then at the very end, she was talking to him. She tells this anecdote, like her talking to him in the story or something, and it came up. It's like, well, what was that? I think she said, what was that or something? And he said something like, well, it was a lot of fun, and everybody was watching, weren't they? And she tells the story like it just clicked in her. She's like, oh, it was all just a big game and a big show. Oh, right. But everybody's playing it. So there is something to that. Trump is a performer. He likes theater, and there's a lot of theater lately. So That being said, I'm asking about like the consequence. What is the consequence of this? We talked a little bit more about it this morning, gaming it out before it really exploded today. But we were explaining it. Yeah, and I think that there's like if let's say Elon wins, the bill is killed, Congress comes back with a better bill, they pass it, we win. Okay. They don't kill the bill, they strip some stuff out, and it's a better bill, the one big beautiful bill. Okay, great. They strip it out, the government shuts down. Trump, kind of loses in a way because he can't have a political victory on that. But that also gives Trump a lot of leverage and a lot of leeway to do things. Like if the government shut down, now there's a real state of emergency on all the deportation cases. We're limited with resources here and there and there. Trump can execute serious reform if the government is shut down, right? Just cut, like we want to cut stuff, cut. We have to, government shut down. So I think we win on that one. And it would be a very big wake-up call for all the people in Congress, right, and the government people, that the government can be shut down and we're willing to do it. So I think that's all upside. The only real downside would be if we have to lose the reconciliation process and do a 60-vote process with Chuck Schumer and then get the Democrats in. Okay, and all that's short-term like strategy. So it's mostly upside, I think. And after Trump is done, we do not want to hand this party back over to the Mitch McConnell types at all. So if Elon's going to be going, I kind of see the Elon versus Trump thing as being also misdirected. It's really like Elon versus Congress. Like it's Trump's big, beautiful bill, but it's Congress. It's like Congress has to pass it. It's the Republican Party, and they're the ones who are screwing the whole thing up. Trump needs to get something done. He's got to like get them to, pay it off essentially. So Elon going after the one big beautiful bill is really just a proxy for going after Congress. And so Congress is right now having a freak out mode. And I think it's all good, right? We do not want the old guard where everything is just like, yeah, we just, they should come back out past 1.7 trillion Inflation Reduction Act. And everybody's like, well, we had to do it because COVID. We're tired of that. So if we have to get a little bit rough and people are throwing plates of broccoli at the wall, that's fine. This is politics. We want real conversations. Now, again, the downside is Elon, joins the liberals or donates 100 million to their cause or something like that. But I think they're both on Team America, and a little bit of disagreement, it's not that bad. What's up, Philip Butler? Aaron Burr unalived Alexander Hamilton in a duel. See, that's what I'm talking about. Yeah, like this is like, they're like tweeting at each other. Like they could be out like shooting each other or caning each other in the Senate. Like they played pretty hard back then. And now like we see a couple bad tweets and a couple sniping. Like it was nothing, man. They used to write these letters and these, articles in newspapers, like these satirical articles that would make other people, not by name, but look like just clowns. They burn coaches and stuff. Like it was rough back then. And I'm not saying that's what it should be, but I'm just saying a little bit of back and forth inside the party. It's all right, whatever. Hans, what's up? Note that Ketanji is the lowest in seniority, I think. And Roberts had her write it to rub her nose in it. I don't think so. I don't think that he would do that. I think that it was probably her opinion. He's like, you want to write this? She's actually the right one to write it, right? So it's like a black woman who is writing this, saying that a white woman is being discriminated against. It's like poetic almost. Yeah, I don't think that she was unhappy about it. Rob, what's up? Who let the dogs out? Who let the dogs out? Hey, Doggone It is here. Hey, still here even after the doggy style comment. It's amazing, Doggone It. I'm glad you're here. And happy anniversary. Hope it was a great night. Sounds like it might have been. So it's great to have you, Doggone It. Thanks for not getting scared off with my weird comments on the stream. Hey, D. Walters. I wonder if Trump and Elon are portraying a public breakup. Elon gets some distance so leftist leaves his companies alone and possibly removes some pressure at his company boards. Trump brilliantly defeats the Democrat messaging about Elon running stuff and favoring oligarchs. Seems plausible. Either way, I believe you're right. A spat between the two will definitely result in common ground and will all benefit. Yeah, I think they're both authentic. I think they both have a lot of passion. They've got disagreements about methodology. I don't like the personal stuff, so much, but ultimately, like, are we going to lose seats or something because of this? What are we going to lose Congress seats because of this? Are we going to lose the presidency? Or is it going to open up an attack vector for impeachment? I mean, Elon might not want to support like the Republican Party, but that's fine. The Republican Party's crap. So if he wants to bring in new candidates who don't do this pork stuff, okay, fine, we win. Like, we don't need all of the Tom Tillises and Lankfords and all those guys. So that's great. If he wants to primary them, the downside of that, right, is that they're incumbents. So if you primary them and they lose, you might have Democrats who have major gains. Like, that's all realistic. But we want a functional government. And Trump and Elon, I think, are both working towards that against the great heft of the bureaucracy. So I'm happy about it. Knox, what's up? Are whites really the majority anymore? When was the last time anyone saw a white guy working construction? Yeah, it's few and far between. Yeah, especially in Arizona and border states. Knox, you're in Texas, so I know what we're talking about. There's parts of Arizona that look like Mexico. And I'm not joking about that. Like, you drive through there, there's all the signs are in Spanish, everything is in Spanish. It looks like, it's run down. It's just disgusting. But, not all of Mexico is like that, but, there are beautiful parts of Mexico, not to besmirch an entire country, but it looks like not our country because we've been invaded. Mizzy M, hey, agree with your assessment on Trump and Elon, both winners and both have the same long-term objectives. Make America great again. Thanks for all your energy and the work in staying on top of the stories. Thank you, Mizzy M. Yeah, thanks for joining us. I know there's a lot of blood sport going on out there, but we just decided we're going to leave mom and dad over there. We're going to go to the Supreme Court's house today. IC Scape, what's up? Thank you, IC Scape. Thanks for becoming a supporter, my man. Grab the morning stream. It was a good one. Chubby Stubby says, given the current politically charged and activist contorted court system we currently have, those lower courts are still going to rule against her with some other Olympic level mental gymnastics. I think that's probably a safe bet. They'll just say, well, you were late and you were fired for cause. And this guy was like much more punctual and his spreadsheet rows were a lot neater than yours, whatever. Probably right. Rob, what's up? The earth makes up 11% of the world population. The earth makes up 11% of the world's population. Stop being racist to white people. Mark Dice uses the word anti-whiteism. Shout out to Mark Dice. Yeah. I think there's a lot of that. Yeah, there's a lot of that actively. Like, they don't even hide that. What's up, Rob? White people make up 11% of the world's population. But in America, we're the majority, I guess. Ravicus, the government needs to get out of the race business. Totally. They promote racism by creating an ugly form of collectivism when they ask on all public documents what your race, creed, sex, age is, right? Divvying you up because you're not an American, you're a Black American or Hispanic American or Caucasian, white, whatever. Says we should only be considered to be citizens and we are all equal under the law as a citizen. I couldn't agree more. We have that in common. Why is it so hard to just say, hey, we're Americans? Rick D, wow, Kagan and Jackson both made the right decision. Yeah, it's like today was like Bizarro land. Trump and Elon killing each other. Kagan and Sotomayor fighting for civil rights for white people and gun rights. What are we in the right? Are we in the right country? What timeline is this? Is this the right universe today? Hey, Jigam, let me do this again. Holy moly. Yeah, so this was a big one, capturing a lot of attention, right? Elon dropped this. Trump made a post like, well, why don't we just cancel Elon's contracts? And Elon said, well, how about we drop the really big bomb? Says Trump is in the Epstein files. That is the real reason they've not been made public, says Elon. Have a nice day, Trump. Mark this post for the future. The truth will come out. And that doesn't ring true to me. Personally, I think that if Trump, first of all, I think that Trump is probably in the Epstein files in the same way that RFK was in the Epstein files and a lot of other high profile people are in there somewhere, in the phone book somewhere, or on an airplane at some point in time. Like, I'm pretty sure Trump flew on the airplane, but those trips were back and forth, like Florida to New York. They were kind of domestic trips. Don't know that he ever flew to the island. And we know it's come up that he's been in there. but not the nefarious components of what was happening on the island, right? That has never been proven or substantiated or even in evidence. And my take on it is that if that were in there, that would have come out in 2016, run 1, would have come out again in 20, run 2, would have come out again in run 3. And by the way, they had the FBI for the first run, and they had the FBI for the third run. So why would they not leak or release any of that information at all? They had a full trial on it. So I don't believe it. I think if it was there, I think we'd know about it. Unless it's a poison pill. Like if you know something bad that Trump did, then that would expose a bunch of other things, right? And so it's like mutually assured destruction. So you can't release it about Trump because it would be devastating to everybody. So Trump is protected because everybody's protected, if you want to go that far. But I think if they had anything plausible about it, it would have already come out. So this to me feels like kind of like crashing out, as the youth of America say. You know, you're just crashing out. It's like, oh! And then Elon also posted that he's just going to decommission the space capsule rocket. Oh, fine. You know what? We're going to decommission that too. It's like, all right. And Trump's like, we're going to cancel your con. I'm like, well, all right, guys, both calm down. Okay, go sit in the opposite corners for 10 minutes. But ultimately, I just think it's a bunch of bravado, quite frankly. We'll see. Doan, Scheinbaum's stupid lawsuit is just a stupid answer to its fentanyl pipeline into the U.S., but both remain a supply and a demand issue. Yeah, so Claudia Sheinbaum, the president of Mexico, suing. Yeah, and so I guess she sued. Doan is saying she sued because of the fact that Trump is tariffing them, says, oh, we got fentanyl coming in here. Well, you send drugs to us, and so we'll just sue you. And it was just kind of a political statement. Good to see you, Doan. Thank you for that. King of Biltong is here, shouting out the Biltong and how you can get protein, B12, creatine, and more at biltongusa.com. And you could use code Robert. Save some money when you do it. Thanks, King of Biltong. Get your Biltong. Whoopsie Daisy says, I found this one interesting over from Instagram. And thank you for that one, Whoopsie Daisy. I'm sure it's good. Knox says, Mexico should be suing Ukraine for selling all the crap we gave them. Mexico. Yeah. Do they care if they sold our crap? Oh, I see. So Ukraine sold our guns to the Mexican drug cartels. And so why isn't Mexico suing Ukraine for that? Good question. Doan says Toxic Emily qualifies as an environmental hazard. Yeah, I mean, she's basically like a bioweapon. Sounds like spitting on everybody walking around. Human bioweapon. Hey, here's one, Spuds. Lugify the patriarchy. Yeah, don't give them any ideas, Spuds. Bunch of psycho women out there loogiing on people, yanking their dogs around. Hawking, get over here with your dog. Diane K. Lacey. 90% of those guns do originate in the U.S. They're sold to the Mexican government, either from the U.S. government or from the manufacturers themselves. It's the Mexican government who sells them to the cartels. ATF has all those serial numbers, and they know. Yeah. I'm sure there's a lot more to that story there, Diane. And and everybody's pointing fingers on that. I think that a wall would just solve the whole thing. No more guns, no more fentanyl, just build it. Mexico? Ravik has shared this one. This is how it felt today on X today. I know, it's how it felt. Everybody was just like this. Now I gotta cut you. It's like, oh gosh. Don't Epstein. No with the Epstein stuff. No, don't with the cancellation of the contracts. No, Trump, don't. They're doing it. Now I gotta cut you. We're all gonna calm down. We're gonna be friends, man. I was having like flashbacks to the Trump DeSantis battle. Remember that? That never really came full circle. So we got some precedent on this, like how things can go bad. Hey, Doan says Emily Lugie and Luigi Mangione can compare notes. Pretty much. Yeah, Luigi. And who was the other dude? I don't remember his name, but he shot those two people outside the museum. It's kind of like what the left likes to do. They have to get violent, shoot people in the back, shoot people in the head, and hawk loogies on their shoulders. Can you guys just calm down? Just go back to blogging or something, okay? Just chill out. Rick D. Hey, Rob and the Watchers. Wanted to thank you and the Watcher community after last weekend and the anniversary of my son dying. Many from here reached out to make sure I was okay. Oh my gosh. Thanks for the family and all you do. I am in a good place and wanted people here to know. Rick, man, thank you for sharing that with us. And my friends out there who contacted Rick, thank you for doing that. Thank you for reaching out and checking on him. Such a nice thing to do. I didn't do that. It made me look like a terrible person. Thank you, Rick, for sharing that. We have an amazing community, and I really mean that. That's kind of, it warms my heart because that's what community is. So it's awesome. Rick, glad you're well, man. Thanks for being a part of our community. Thanks for sharing your experience with us so that we can be a part of it in a small little way and go through it together with you, because many of us are doing the same. Thank you, Rick. What's up, Jigam Geegum? Hey, thanks for putting together such incredibly interesting shows. Oh, no. Oh, that's my squid. Oh, I ate squid on the members only stream. Yeah, that's about how it was. It was a traumatic experience for your boy. See, that's the squid right there. It had an interesting texture. I think you can see it go bad. Yeah, there it goes bad. Okay. It's a little strange. Yeah, so that's squid from Japan. Yeah, it got stuck in my teeth there. So Jigam, thank you for the great meme. It came from Japan. Look at that, man. We ate it. Yeah. Shout out to Heavy Johnny for getting us that. Heavy Johnny, amazing. Sent us a bunch of goodies from Japan. We had a whole trip over there. It was a lot of fun. Thank you, Jigam, for the great meme. It was an experience. It was an experience. And you can see it right on my face. Uncle Bozy, hey, I read an article this morning concerning Trump and Musk. The writer pointed out that the Democrats have switched from Trump as Hitler to Musk's oligarchs are evil manipulators of the government, using Musk as their own example. So this rift has thrown the Democrat strategy for the next election into disarray. Can't slam Musk if Trump agrees with them, now can they? Well, that's the thing. It's like, yeah, a bunch of Democrats, even Chuck Schumer was out like, I can't believe I agree with Elon. Wait a minute. So you were just like attacking him as being unethical, dishonest, bad judgment, and all the things, and now you agree with him. So it's just about the politics then, right? Got it. Ravicus, will Lindsey Graham ever face justice? Probably not. That's the problem. That's why we're so sick of these Congress people. That's what I'm talking about. It's like, when Trump's over, I don't want Lindsey Graham to be back in charge. So if we're going to start reforming things right now with Elon and shake the tree right now to prevent that, all right, got to do it. Mrs. Mom, Elon posted that Trump is on the Epstein list. I know he says that. Thank you for flagging it for us, Mrs. Mom. The Epstein list, like, is he in the phone book? Probably. A lot of people in that phone book. Is he on the list of clients that Epstein had, that he was providing youth to, that were being human trafficked? I don't think so at all. I think we would have seen that already come out. They tried to imprison Trump. They indicted him on 4 made-up charges. If they could have gotten him on something more serious than that, I think they would have. So I just have my doubts about it. Yeah. Uncle Bozy, I wonder if they will make Spit Girl wear a spit mask at her bond hearing. Yeah, that's the thing. If you're known as a spitter, they'll gag your mouth. They'll put a whole hood over you, a spit hood. Spit on yourself if you want. Doggone it. Great things have to wait. Oh man, husband is on the ocean coming home from Israel. Merchant Marine. He's a captain of a ship. I'm a captain at home, kinda. Doggone it. Well, you celebrated your anniversary from afar, from a long distance celebration. Sounds like when you get home, you'll make up for that time. But safe travels to your husband and to your home as you both captain your ships. Thank you, doggone it. What's up, CF Rob? What's up, Rob? Hey, Canadian, Central, and South Americans are all Americans. U.S. citizens, United States Citizen Immigration Services. We are all U.S. citizens. Do you think that people from like Central America, do you think they call themselves Americans? I don't think so. What's up? Call me legend. Hey, sorry I missed a couple shows. Have you covered the judge who stopped the Colorado firebombers' family deportation? No, not yet. I did see that one come through. We have not covered it yet. And are they still here, or are they gone already? Yeah, we haven't covered that one yet, but thank you, Call Me Legend. We got this one from Uncle Bozy. I'm 70. When I was in grade school, a buddy and I got into a fight, and Miss Allen made the both of us sit in front of the class and hold hands. Sadly, Mrs. Allen has passed away, so we can't send her to D.C. to handle Trump and Elon. So, Uncle Bozy, you know my story about this. My mom used to make me and my brother do that. Actually, we did it once. Like, she made us do it once, and we never misbehaved again our entire lives. I have a real story about that. My mom can confirm this. She made us sit there on the couch. Like, no, don't move. Hold hands. We sat there for like an hour. It's the most horrifying experience of my whole life. And I never misbehaved again after that. I forget how old we were. It must have been like 10 and like 7 or something, or like maybe like 12. Like, when is it most awkward? Probably like 12 and 9. Like, what is this? It worked, Mom. It's good strategy. We should do that. Yeah. Mrs. Allen. She could do that too. All right. We need a Mrs. Allen to come in here and make Trump and Elon hold hands. Leonard, does anybody believe Brandon was really studying any documents and signing them? No. No, we don't. Not at all. And the DOJ launched an investigation, or will be, courtesy of Trump's executive order proclamation. We read that this morning. Frog Feeder, one day we'll all be dead, and none of this will matter. Are you that Senator Joni Ernst who said that? We'll all be dead. It's true. Doesn't matter. So, guess can just do some meth or whatever. You know, who cares? So, no, I think that's not the right answer, but it is ultimately true factually. So, I think that's right. Uncle Bozy, what is this? Hey, I found this on Facebook. Looks like you have a clone that's a barber. Looks like you a little. Yeah, I think you're kind of right. It kind of does look like me a little. Is that a real picture? Kind of looks like an AI picture. But yeah, he kind of does. Kind of looks like me a little bit. Yeah, handsome dude. All right, so my friends, thank you so much for sending those in and for being here, being amazing watchers and friends of the show. Let's say what's up to our friends on X on the day. Then we're going to come back. We're going to do a members only after party and figure out what's going on over there. And we'll call it a day. But let's see who's on X. Make sure we're coming in loud and clear over here. And I think, are we or not? Are we live on X right now? We just posted a bunch of videos. I can't tell. Maybe we're not live. All right, maybe we don't have anything going on X. Okay, no comments on X. So we'll leave it there, my friends. What a beautiful day it is. So X did not work today, so we'll continue to work on that. Gloria B. Sinus surgery last week. Been rough. Okay now. Thank you very much. Gloria B. Great news. Glad you're on the mend. And hopefully you're going to be inhaling and breathing beautifully all the air you can possibly muster. All right, my friends, it has been a beautiful stream. Thank you so much for hanging with us. Thanks for being here. We are going to pause for the evening. We're going to go over to locals at watchingthewatchers.locals.com and YouTube. We're going to flip up a members only after party, but we're using new software, so it might take me a minute. So we're going to figure it out, my friends, but thank you so much for being here. Thanks for inviting somebody to come join us tomorrow. We are coming back here to getting into it again. Before we wrap it up, I want to thank our mods and our meme smiths. We got Jigam Geegam. Thank you, Jigam, for the beautiful stuff today. Elliot, Docmaster. We got Dog Digger, Janek, Neuro D over on the Rumbles. Shout out to Donut, John, K-Bean, Carrie B, modding the fort down for us, keeping things nice and beautiful and orderly around here. And my friends, that is going to be it for us on the day. But, Membos, stick around. And my friends, we'll be back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.
watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chatting line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay each night together and live